here at Meckler Media, so feel free to ask me any questions or make comments throughout the rest of the day. We had an exciting keynote this morning, and we had nice standalone session afterward, and now we're going to have our first blockbuster panel, and the reason I call it a blockbuster panel is we've got some pretty heavy lifters on here, people who have come in from the US and in various places to share their intelligence with you. Last year we ran the same panel, but it changes all the time. You know, the topic is constantly changing, so it's always fresh. In order to keep these heavyweights under control, we've got a moderator named Marco Santori, who's an attorney with Pillsbury, Winthrop, Shaw, and Pittman. That's a full-service law firm with an industry focus on financial services. Marco's been described by American Banker as the dean of digital currency lawyers. Look at that. That's great. He's been featured and profiled in the Wall Street Journal, Forbes, Washington Post, New Yorker, and Wired. Recently, he won the first annual Blockchain Award for Bitcoin Legal Expert. He's moderated several panels for us before, spoken on different topics. If you like what you see, he'll be doing the same thing in New York. In fact, Brian, also, who's one of the panelists, will be in New York in a few weeks. So I'm pretty excited about this. I think we've got a wide range of personalities. We're going to cover a lot of territory. And I'm going to stop talking because I want to give them as much time as possible. Let's give these guys a big round of applause. Welcome.
Thanks very much, Stuart. So my name, Stuart said, is Marco Santori. I'm an attorney with Pillsbury Winthrop in New York City. I chair the Bitcoin Foundation's Regulatory Affairs Committee. And I moderate lawyer panels. So you've got 5 of us here in front of you today. If you can't get free legal advice here, you can't get it anywhere. And so what I'd like to do is start with a few introductions. We'll start on the other side with Brian Klein and come all the way back to me. So Brian, why don't you introduce yourself and say hello to the audience.
Good morning, everybody. Brian Klein. I am a litigator and criminal defense attorney in Los Angeles. I represent a lot of players in the industry. I represented Eric Voorhees in his settlement with the SEC. I also volunteer as the outside general counsel of the Bitcoin Foundation. So I'm very involved in this world.
I'll make a correction. We have 4 lawyers here.
That's right.
Don't insult.
I am not a lawyer.
I'm so sorry.
I'm here to break up the monotony. But no, I'm the founder and CEO of a company called GEM, and so we're a full-stack developer platform for building Bitcoin and blockchain apps, and here to take sort of a founder's perspective on the legal side of things.
I'm Vaziri. I'm director of DIACLE. We specialize in compliance and law for digital currency businesses and blockchain projects. I'm also director of the UK Digital Currency Association. So it's a policy body and industry. We represent the industry within the UK and liaise with regulators, etc., with regards to the regulation of Bitcoin and digital currency in the UK and Europe.
Yeah. Hi, everybody. I'm Lutz Auffenberg, German attorney at law from Frankfurt. We're from WINHELLER law firm, specializing in banking and finance law as well as tax law, but that's not my field. I'm only in the banking regulation law. Well, we work on Bitcoin since maybe 2 years. Have a lot of clients who want to start businesses, startups, or existing companies who are interested in using Bitcoins as a means, accept Bitcoins as a means of payment or something like that. And so we get into this topic deeper and deeper. And so I think I'm the only German lawyer in this round.
Well, you know, on that note, we're here in Berlin. We're all here in Germany. Most of us are visiting. So why don't, Lutz, why don't you take us through the German treatment of digital currencies? How is Bitcoin regulated here in Germany?
Okay. Most of you maybe will know that, but the competent authority, BaFin, in Germany stated very early, already in 2011, that Bitcoins are considered as financial instruments. This has not been subject to any court case until now, so we don't know if this legal opinion of BaFin will last forever. But until now, their opinion is, of course, almost the law, so everyone has to follow this opinion. And therefore, companies who want to do Bitcoin-related businesses do require a license for their businesses.
And so does that apply to all digital currency businesses, or only exchanges, only payment processors,
Yeah.
or do we even know? Is it even that clear in Germany?
See, for example, the Bitcoin exchanges, they mostly do brokerage, and brokerage is considered as a financial service in Germany. So, well, actually all over Europe. And that's why they would need a license, because brokerage is a financial service that is regulated. It depends on what you want to do. If you just want to trade Bitcoins in a very low extent, then that's no problem at all. But if, for example, you would do it in an extent that makes necessary professional accountancy or something like that, or you want to do it commercially, margin trading, for example, then it would also be possible that you do proprietary trading, which is also a financial service. So that would be regulated as well. So you really have to take a close look at the details.
That's interesting. So, so being from the United States, my specialty is, well, my focus, I should say, is in U.S. law, and so it sounds like Germany beat the U.S. to releasing guidance by 2 years. Well, probably 2 years. And in the U.S., our FinCEN, our Financial Crimes Enforcement Network, in 2013 released guidance that says, look, digital currency trading, if you're exchanging digital currency or acting as a financial intermediary for digital currency, you're a regulated entity. You're a money transmitter in the United States. And it also sounds like that guidance that FinCEN put out is similar to the guidance that we see here in Germany, in that it doesn't actually carry the force of law. It's not a law, it hasn't been tested in the courts yet.
Yeah, exactly.
Lutz, I'm sorry if I interrupt. Have there been enforcement actions in Germany? Because in the U.S., FinCEN has tried to enforce things, and state and federal authorities have been enforcing laws.
The financial authorities or BaFin is taking a close look at all newspapers, and they are searching on the internet every day for new Bitcoin startups, and every time they see somebody trying to make up something new, they investigate on that case, and there have been many, many cases where people just didn't know that Bitcoins would be considered as financial instruments. They didn't know that there is bank regulation at all. They just came from the development side and technical side, and they just started something, and then of course BaFin is contacting them and telling them that they are doing a criminal offense if they provide services, financial services, without having the necessary license for that.
And do they just shut down, or do they get fined, or what's the usual
Yeah,
consequence?
you can get fined, but you can get shut down from one day to the other, so immediately. And that's what happens all the time, yeah.
I think you can actually contrast this position in Germany, which is a very, very clear one, and bearing in mind that the German laws are deriving from an EU directive, you know, for example, MiFID or Payment Services Directive, and contrast the approach that the German regulator has done in terms of these EU laws and determining how they should apply to businesses involved in Bitcoin to what's happening in other countries in the European Union. So, for example, I'm based in London, and the equivalent regulator, Financial Conduct Authority, has deemed Bitcoins at least to sit outside of regulated financial instruments. So if you're a Bitcoin business and exchange in the UK, then you are not required to obtain a license from the FCA. So this is an interesting discrepancy because the UK regulator and BaFin are interpreting the same law in essence, but arriving at different conclusions. So you can contrast that position in the UK with, say, Luxembourg, which is viewing a Bitcoin exchange under a different set of laws. In this instance, the Payment Services Directive, as opposed to MiFID, which is Markets in Financial Instruments Directive. So you've got regulators across the European Union all looking at the same piece of paper but interpreting it differently. So then the question abodes, what will happen at a higher level within the European Union? Because all of these regulators are taking stances applied to their national context, but all of those stances may be overruled by a position that comes from the EU. So at the moment, it's a question of countries within the EU and associations representing Bitcoin businesses to rally together to bring the conversation to the European Union to achieve something that is pragmatic. I mean, our position, for example, in the UK, at the UK Digital Currency Association, has been to liaise with regulators. Well, HMRC, we managed to convince them that you should not apply VAT to a Bitcoin transaction. They reversed their position, and now it's exempt, but that may be overruled again by a decision of the Court of Justice of the European Union. But our position is to align ourselves with other associations to bring the debate to Europe and to achieve something that's pragmatic, that achieves a level of consumer protection, but does not destroy the startup community that's gradually evolving.
So Adam, you mentioned consumer protection. What is the main concern? What is the primary regulatory focus in the UK on consumer protection issues?
Well, I mean, the FCA, its design is to protect consumers.
And the FCA is?
The Financial Conduct Authority, so the equivalent of BaFin. Its design is to protect consumers. Now, that design is there for protecting primarily consumer funds, so client assets, but also ensuring that consumers are dealt with fairly, okay, so that your brokers, when you go to them, they're not ripping you off. And adding that element of security that you can feel you can engage with the financial system and feel that it's not going to screw you over. So that's the design of the FCA. It's all centered around the consumer. And the 10 principles, main principles for financial regulation in the UK, all have a consumer focus. So if the FCA is saying Bitcoin businesses fall outside of their remit, then what recourse is there for consumer protection?
Right, and we see that in the United States as well. On the state level, we have the federal government that's primarily concerned with anti-money laundering and preventing financial crimes, whereas on the state level, and we have 50 different jurisdictions to deal with, the governments are primarily concerned with consumer protection. So I think we see that divide in a lot of different jurisdictions. But so moving on for the moment from civil law and regulatory work, what about the criminal side? We have Brian Klein here, who is one of the country's foremost experts on this topic. What should Bitcoin businesses be doing? What should they be concerned with to protect themselves from criminal liability? And don't say just follow the law.
Well, everyone should just follow the law. No, I think from my perspective, sitting in the U.S. and dealing with U.S. law enforcement a lot, whether on the state and federal level as they scrutinize Bitcoin companies, the view in the U.S., especially the Department of Justice, which is the federal prosecuting authority, is they don't care where you're located. If you're breaking U.S. law and harming U.S. consumers or harming clients or somehow laundering money, they don't care if you're located in Romania or Thailand or wherever. They will try to get you. And they have, frankly, the resources and the legal treaties with countries to do so. That makes the U.S. sort of, with Bitcoin, is from what I can tell, basically the world's policeman. There have been some actions, like in France, I don't know if people know about this, but I think it was last year, the French police took down a Bitcoin exchange, seized some Bitcoins. There was one in Germany like that. More recently, there was an action in Hong Kong, although that doesn't seem as Bitcoin related, anomaly as with MyCoin. So there are local enforcement actions happening, but I think for the time being, it's really important for entrepreneurs here in Europe to think about, are they touching the U.S. law in some way? Are they somehow making themselves subject to U.S. jurisdiction? It's an unfortunate sort of thing to think about when you're trying to innovate and develop a product, and you really want to be Europe-focused probably at first even, but you really have to think about that because U.S. law enforcement is not afraid to come after people.
I have to say, I've found that same thing. I feel like there is a big chunk of my own practice that just exists to explain to clients how to avoid U.S. jurisdiction on the civil side. I'm sure you see that on the criminal side as well.
Yeah, I mean, there's a way to structure your business so that you're not dealing with U.S. law and you don't have to comply with it, and it's proper the way you've structured it. And there are people who accidentally trip over that, and they don't realize taking U.S. customers probably makes them subject, depending on their business model, to U.S. law. So there's lots of different ways you can accidentally trip over that. And I think, you know, as Bitcoin gets bigger, you're going to see more European criminal enforcement actions. I mean, it's still a very small economy. It's it's about $5 to $4 billion market cap for all Bitcoins. So it's still a very small emerging economy. But one thing Bitcoin does generate is headlines. And a lot of prosecutors love to see themselves in the headline. So, you know, if they take down even a small company, if it was just a normal financial services company, they wouldn't be on the front page of the Wall Street Journal. But if they do it with Bitcoin, they can get that headline.
And Brian, and I should say Brian knows this. But he's modest about it, but he's a former prosecutor, so he knows the psychology on both sides of the table.
So I'm curious to hear what Micah, who runs a business,
Yeah, I'd say it's very difficult. I think to as a founder, you're tied up with so many other concerns like, will I have customers, or can I pay my employees, can I raise funding, that, you know, thinking about the regulatory side is probably pretty low on most people's list when they're starting a company. And on top of that, you know, Bitcoin is international by its very nature. So you're out of the gate dealing with a regulatory regime that changes not only from state to state in the United States, where it's very complicated, but then, you know, international laws. It's just, for the average startup to be able to navigate this field is practically impossible. And so I think that's actually why, more often than not, they ignore the regulations and then maybe get into trouble later. So I think some unity or you know, better clarity on regulations around the world for this thing would be really helpful for startup founders, but it's also very difficult because everybody, like you said, views it very differently, even when they're looking at the same piece of paper. So it's actually a real problem, you know, and uncertainty is the biggest killer of something like a fundraise for a startup founder. It's really hard to raise money from investors when they're not sure of the regulatory environment either.
I mean, so have you had that experience? Have you gone to an investor who likes the product, sees that it's innovative, sees the market uses and the potential for growth, says, look, I just don't know whether you're going to take my check and just hand it over to a lawyer for attorney's fees?
I don't get that directly, but I think that there is a sort of cost-benefit analysis that's going on in the investor's head, right? So it's not necessarily that it's an either or, it's a yes or no. It's that gets factored into their decision-making process around whether they're going to fund a company in the Bitcoin space versus in, say, the Internet of Things, or, you know, whatever other choices they have. And so it does play into that. You know, I think investors are typically very bullish on Bitcoin, so they're willing to overlook some of the uncertainty. But you know, it's getting harder and harder. You know, when things like the price of Bitcoin goes down, it actually has a real effect on investor sentiment. And what happens is these investors start to consolidate their funds towards companies they know who can afford the regulatory uncertainty. So they put all their money into Coinbase, which is, you know, why you've seen $100 million go into that company. And then what it does is it creates a competitive landscape that's very much more centralized, which is exactly the antithetical point of Bitcoin, right?
But you have to, I think, I mean, I appreciate there's an element of uncertainty, but you can have a strategy, a licensing strategy in place, depending on where you are with your business. If you're at seed round and you want to operate an exchange and you've only got like 10 or 20,000 pounds or dollars to spare, then you're not going to go very far. You probably need to locate yourself in a place like the UK where no license is required. At least in that jurisdiction, you won't have any trouble with the local regulator. But then you need to consider the US market, maybe turn off some IP addresses. That limits the scope of your market. But once you've demonstrated that your technology is sound and that you have a differentiator within the market, then in your next round, you're in a position to acquire a better license. such as get an EU license that you can passport across 28 states in one jurisdiction, and then you've got access legitimately to a whole region, and then approach other markets differently. I mean, the fundamental problem I have with the US market is you can't access that market, just like binary options and online financial brokers used to try and access the market, and it was illegal. The alternative is to go into the US and try and get a license, but to do so, it's the most expensive approach in the world. I mean, maybe you could touch on what the procedure is and
So
the expense involved.
I think that so one of the reasons that so many people are, have understandable trepidation in entering the U.S. market is because it's not just one market. It's not just one government that whose laws you need to address. It's 51. In the United States, there's the federal regulator, FinCEN, who, and we're assuming we're just dealing with currency uses of the Bitcoin protocol and not, securities uses or futures or that sort of thing, and other derivatives. If all you're going to do, say, is open up an exchange, it's a business model that a lot of us understand. You're looking at satisfying a federal regulator, that's FinCEN and Treasury, which is, like I said, concerned with anti-money laundering. It means getting an anti-money laundering policy in place. It means appointing a compliance officer. And of course, registration with FinCEN. But really, that's not the heavy lift. You're talking about, a low five-figure outlay cost-wise. The real heavy lift is on the state level, where you have to satisfy all these different jurisdictions. And in the United States, it's a little bit different in that you're not just notifying the federal government that you're doing this business. On the state level, you're asking permission, you're seeking a license, and that process can take up to a year, and in fees, depending on the business, maybe $750,000. It is a process, right? And then there's all these other requirements that come along with this, bonding requirements. You have to seek bonding. So if you end up getting a $50,000 bond for one state and a $100,000 bond for another, and so on and so forth, you end up paying a small percentage of those bonds every year as a fee. There's minimum capitalization requirements, which ensure you can't just start a financial services company in your garage. You need to have some amount of capital in the bank. So it seems overwhelming to a lot of people, but it's important to recognize the difference in business models there, because not all business models need to do that. You don't need to do that every time when you enter the US market. If you need to access every single state, you need to access consumers in every single state, then maybe you do. But if you can localize your services, if you can eliminate some states with more onerous requirements, then you can mitigate that considerably. You can enter the U.S. market without having to deal with all of that outlay.
There's also a lot of the Bitcoin 2.0 companies that don't, they're not really covered by their business model under FinCEN or the SEC or European regulatory bodies. There's lots of business opportunities where the regulatory regime that covers you is much, much smaller and much more easy to comply with.
Yeah, that's absolutely right. So just because you want to do business in the U.S. doesn't necessarily mean you have to go out and get a bunch of licenses. It depends heavily on the business model. If you're not using the Bitcoin protocol for a currency implementation, then chances are you really don't need those licenses, even if you're just moving a few Satoshis around for the purposes of tracking a colored coin. You usually aren't implicated by that stuff.
That's only really recently clarified, right? So,
yeah, and for a very long time, that wasn't necessarily the case. We didn't know for sure, but now,
And also, it's still unclear, for instance, if you do both. If you are both using Bitcoin for the currency aspects or using it for blockchain 2.0 technologies, then at least under the current reading that I've read of the recent guidelines, you would still be responsible for reporting any sort of suspicious activity reports, regardless of whether it was a Bitcoin 2.0 or regular cryptocurrency application, because it applies to the business, not to the transaction level. So you have to sort of pick an either-or model, and you can't touch both. So there's some clarifying that I think needs to be done. I think it needs to be thought through a little bit more. And that's the kind of stuff I think where, when the regulators start to sort of dictate business models, I think we should be worried and concerned because it makes it very, very difficult for guys like us to sort of navigate how we build a business, you know, and like we want to follow the regulations, we want to do the right thing, but when these regulations make it very hard for us, it actually does have a very serious, very big impact on innovation.
But
I
I
think
mean,
that's
Micah,
right.
even if you are unregulated, if you're unregulated in the European market and you identify a suspicious activity, even if you're unregulated, you are bound to report that. And if you don't, basically you're going to jail. And that has totally beside the point of whether you are regulated or not. If you are regulated, then yes, you need to do, in addition to those reports, you need to give your staff training on AML. You need to record keep. You need to do customer due diligence, enhanced due diligence, all of these things. And bear in mind, all of this AML stuff stems from the same FATFA recommendations, you know, the 41 recommendations. So the implementations in the US, Europe, are actually matched in principle. So, you know, I think the clarity is, if you are an unregulated business and you are dealing with Bitcoin, or any financial instrument for that matter, if you identify suspicious activity, you better report it. It's as simple as that.
I think my point is more that the government is assuming that all Bitcoin transactions are actually financial transactions, and that's just not true. A lot of Bitcoin transactions can be used for moving assets that have nothing to do with money. You can use it to create distributed voting systems. You can use it to navigate, you know, authenticating with your car and the Internet of Things, for instance. So these are all things that are transactions between two entities that aren't necessarily, by their very nature, considered financial transactions. And I actually think that, you know, as an industry, we sort of did ourselves a bit of a disservice by starting with money, because we dove right into the most heavily possibly regulated industry. And all the other use cases that the blockchain purports to support are now seen through the lens of what FinCEN thinks on, you know, an Internet of Things transaction, which makes no sense at all.
Yeah,
I will say this, I think, having dealt with a lot of criminal and enforcement authorities, they are willing to listen to your story about what your business model is really trying to do, and if they think you're acting in good faith and really trying to diligently follow the law and regulation, it doesn't totally insulate you from everything, but it's very helpful. And, you know, Bitcoin is exciting for us in this room, but it's also exciting for the prosecutors and enforcement authorities. They're trying to learn it just as much as everyone else. So there is a chance, and a lot of times what I end up doing is telling a story, not making up a story, but telling like what my client was trying to do and why, you know, they were acting in good faith and why they were trying to comply with the law. And there's a lot of, you know, fog out there about what the law is.
I think
that's
right.
important to keep in mind. You know, if you're acting in good faith, that's going to take you a long ways towards solving your problems.
But you need to be competent at the same time and
Yes.
understand what the risks are facing your business and have appropriate measures to address those risks. It's not sufficient to say, I'm a Bitcoin business, all I do is KYC. I just accept my customer documents and follow what another financial institution would do, you know, by mimicking a loan. That's not sufficient. You need appropriate measures for the technology that you are dealing with. And those appropriate measures could include blacklisting. They could include tracking IP addresses on transactions. And that's the type of intelligence that you need to be developing. And the positive point is, from my readings, at FinCEN, you may correct me if I'm wrong, they're quite impressed with the quality of reporting that they're receiving from Bitcoin exchanges. So that's a positive point.
That's what they have said. I mean, overall, I mean, look, FinCEN has problems with major companies, HSB, I mean, big banks, big financial institutions. They're not, they're focused where the money is, and it's not really in Bitcoin. So, I mean, they're looking at major institutions all the time. I think you're right. Like, good faith implies, to my mind, like competence in taking the appropriate measures, and, you know, working with lawyers and trying to do the right thing consistently.
Yeah, I think that's right. And one of the examples that we've seen, and just I guess to wrap it up, I think we're running short on time, but one of the examples that we've seen of this process, this dialogue between the industry and the regulators, has been what's happening in my home state in New York with the BIT license, which is something that I'm sure has gotten significant press all around the world, as well as in the United States. And the first version of this proposed bit license, this digital currency specific license, didn't make any distinction between Bitcoin 2.0 applications and currency applications of the protocol. The industry, myself included, representing companies, went to DFS and said, look, there's a real difference here. One is a bona fide transaction in currency that has consumer protection concerns and all these other reasons, anti-money laundering issues, all these other very good reasons why a government might want to step in. And on the other hand, you have things that are trading loyalty points and digital assets that there are probably some consumer protection concerns involved, but they're not the same ones that reinforce and mitigate the concerns that you're primarily interested in. And then we saw the result of that. We saw the second version of the bit license, which contained a carve out for non-currency transactions. And it worked. I mean, it was a great example of an industry engaging with the government, engaging with regulators, taking an affirmative position on something, and affecting real change.
And I think we should go one step further than that. I mean, Europol has just issued a report. I mean, and in that report, it's not pretty how they're painting the landscape of digital currencies and its use within a criminal context. My view is the level of engagement should be intensified with regulators and law enforcement, especially regional law enforcement agencies, so that they know that they have the tools at their disposal to fight the crime that's occurring within the blockchain, etc. Because, I mean, we are an industry that's emerging. If the perception of our industry is that it is primarily being used by organized criminals, then we're not going to go very far. So the level, the whole industry as together needs to rally and face those risks in a pragmatic, not a naive way, but in a pragmatic and realist way, and provide the tools to those people who can actually do something about it. So, I think we all need to be engaged in this process. That's why, earlier I was referring to everyone reading from the same sheet of paper but interpreting it differently. We need to bring that dialogue to the European Union and all of the related law enforcement bodies so that there's consistency and it's not us against them.
I think that's spot on. So with that, we'll open it up to probably, I would hope, the more productive portion of this this talk, the free legal advice portion. Please. Brian hates it when I say that. No, it's not legal advice. It's just general information. Please feel free to ask any questions you'd like.
Questions?
We'd be happy to help.
Yep.
We know that the main point out of hypocrisy, the main point of the decentralized property network is also to be resilient to government attack. I mean, of course, eGold had a hackers attack, but the main reason eGold is not here and Bitcoin is here is that eGold was fragile on a government action point of view. So the main point of cryptocurrency is, no matter what we say, to be anti-fragile and to be resilient also to legal and political attacks, regulatory attacks. So my question is, given that if blockchain technology succeed is also because this is true. And so if regulatory environments start to be, they can either leave startups live freely and make it easy for them, or bring startups, bring innovation on a DAO side of things, Silk Road. Bitcoin itself is not a startup, it's a DAO. So my question is, in your experience, are you also dealing with people trying to protect themselves from the association of their action to an actual enterprise? I mean, something like a Ulbricht process, you are also working on how to protect people who choose to use the real power of crypto technology, decentralized platform, and to start an open source project which can be used dark wallet, I mean, which can be used by people, peer-to-peer, and then regulatory environment or state can take these people accountable for the creation of the free open code, which he doesn't even monetize directly. So are you dealing with these kind of problems, and how?
Yes, yes, yes. The answer is yes. I think that we're seeing more and more of that, especially in response to a growing body of regulations. We're seeing more and more people trying to come up with innovative ways to step back from that, just like Satoshi sort of released the code into the wild and then stepped back. And there's a lot of people that want to be the Satoshi of whatever the next thing is and be treated in a regulatory sense like Satoshi is treated, which is not at all. And I think that we've seen that with varying degrees of success with people. One great example is organizations now forming foundations that will shepherd a new protocol that really just a bunch of developers that otherwise would have started a startup. And then the foundation will act as a nonprofit to shepherd the protocol, but the protocol itself would be open source, whatever it may do. You see a separate organization that, to a greater or lesser extent, achieves some of those same goals.
I think one of the better examples of that is around exchanges. I mean, if you really think about the most heavily regulated businesses in this space, it's usually the exchanges where fiat actually changes hands to Bitcoin and back. And so there's a lot of work. There's been a lot of white papers and talk on the forums and Reddit and everything about building decentralized exchanges. I think that's going to be a growing issue for the next year. There was actually one that came out just this week.
Yep.
And you're going to see more of that kind of development happening. Basically, people trying to build around the law. Yeah.
Which is creative and good and is part of the trend towards decentralization, which is inherent in this technology. However, it's all very well, trying to, again, we're playing whack-a-mole. So the regulator comes, hits Bitcoin, and then someone comes out with another system that is, basically a tumbler in a wallet. But if you look at the Europol report, they're saying, well, it's not that we can't, go as a tumbler and track back where it's coming from. It's just resource intensive to do so. So you're going to always have, law enforcement's not just going to say, okay, cool, that's great, decentralize as much as you want and, have online drug marketplaces. But the point is, if you want this technology, you can't destroy it. It's not going to go away. It's BitTorrent, essentially, with money, with everything else. It's not going to go away. And regulators know that. The industry, the incumbents in this industry are starting to understand that. But the point is about how you can engage with those parties, the incumbents, etc., for them to understand the technology and bridge the gap between the two so that it's not us and them.
I think that's part of the beauty of our industry, in that we are all working around this neutral protocol, and we can go about it in different ways. There are those that I represent who engage me specifically to reach out to regulators and sit down with policymakers and talk about this stuff. Then there are those who say, look, I don't want to deal with any of that. I want to decentralize all the things. I want to be completely decentralized. How can I best achieve that? How can I best mitigate those risks? And I respect those attempts to do it. I think that some of them have been very successful. I think the decentralized exchange is really, at least under US law, one of the holy grails of regulation avoidance.
And the other holy grail, in my opinion, is multi-signature stuff. So, we have the tools available to basically build better software that actually prevents the ability for consumer protection failures. So Mt. Gox was a huge problem because a bunch of people trusted some guy in Japan with all of their money. Multi-signature schemes allow you to essentially have all the services that you want, be able to move money around, be able to buy and sell things, move value, without ever having to turn over your property or your keys to any third party. And that is like one of the most amazing inventions, I think, of our lifetime. And it's actually going to be extremely powerful The problem right now is that there's a huge gap in understanding between what regulators know and what the Bitcoin community knows and what is possible. And I brought this up we're at the Council for Foreign Affairs, right? So they just don't understand the technology. I think that we need to do a better job as a community to figure out what the regulators want to achieve and then come back to them with a technical solution that solves the problem of what they want to achieve, rather than having us develop the technology and then having them try to fit square pegs in round holes to see how it can fit in.
They don't like things they don't understand.
Right.
Then they don't know what to do with it.
But a really interesting point is the One Bank report came out from the Bank of England, and one of the experts was mentioning that capital, which is the linchpin of regulation, so securing your client's assets, how do you guarantee that? Well, you place the expectation that that entity has a lot of capital. Well, the One Bank report was talking about, how the technology could actually lead to a situation where you need to reevaluate whether capital is a requirement or not. Because if it's all in multi-sig, then do you really need a capital reserve? And so there's some acknowledgement and awareness, even from central banks, on this matter.
Thank you. My name is Thomas from Frankfurt. To the European colleagues, a question. If I set up a payment service provider in the UK, I would call it Bitcoin heaven. And I go to the US, it's clear, I understood, I need a license if I want to conduct business there. But since I'm in the UK, I have no license, I'm not regulated. What happens if I want to conduct business in other European states?
That's not possible at all. You can't use a European passport if you're not regulated. You will need the license, so the only thing you could do in the European Union is to go to the German market and get the license here, because nowhere else in the European Union you have the possibility to get the license. That's a very frequent problem, actually.
Although there's, this is a question of online services, yeah? So if you have a position in Germany which is clear, saying that this is a financial instrument, you cannot provide services to that market unless you have either a passported license or the license in Germany. However, in other states in the European Union, where the position hasn't been defined yet, then that position is one of a grey market. And we all know about grey markets in online financial services. You could locate yourself in the Isle of Man and service all of the grey markets in the world. What is a grey market? Well, it's a state where they have not defined what their regulatory position is, and as a result, you have freedom to provide your services there in principle, subject to, I would always advise, check with the local regulator. But my point is, if in Spain they're saying we don't regulate this, then it's a free market for you. If in France they're saying you need a payment services license, then you can only passport there.
Hi, my name's Callum, and I'm Scottish, so the idea of free legal advice speaks to me very strongly. We love a freebie. We're building a decentralized remittance network, and I wondered, following on from the earlier question, if you have any advice in terms of how distant do we need to be? If we build a technology that's sort of similar to Bitcoin in the fact that it's decentralized, can we operate nodes but still be kind of exempt from regulation, or can we just release the software and have other people run the nodes? Like, how do we make sure that we are not subject to regulation?
You do it in the United States?
It's global, so it's like Bitcoin. You can run the nodes. You can move the stuff anywhere. It recognizes no borders.
Well, there's probably something that ought to be said here. And the regulation is generally a very highly fact-specific question, and so I've worked with people who are putting together remittance platforms that are decentralized in one way or another. And we all love the D word. We all like to say decentralized. But just because you say decentralized doesn't mean that we both think it means the same thing, or it actually means the same thing. And I would be very interested to know more offline about how the market is decentralized, how the platform is decentralized. Because typically, at least under US law, you're looking for intermediaries and custodians. Intermediaries are important because from a money laundering perspective, the government is looking to regulate nodes. They're looking, like you said, nodes. They're looking to regulate intermediaries, financial intermediaries, not the users of the system, but the proprietor of the system. Then on the state level, from a consumer protection perspective, intermediary or not, what we're looking for is custodians of value, whether it be in dollars, euros, or digital currencies. So I think that it's probably going to be difficult for us to give any advice, but generally speaking, it's the kind of fact-based inquiry that probably bears speaking to a professional about.
Thanks.
Cool, we got time for one last question over here.
Hello, it's Sean Jones from EdCab. We're a Brussels-based public policy platform. Regulation is one of the key challenges of this new crypto world. The other is defining what this crypto stuff is, this decentralized stuff is, because of the consequences and the impact that it might have on, for example, taxation, an issue that's right at the fore at the moment in the European Union, where this very question has gone forward to the European Court of Justice. Since we've got 3 jurisdictions represented by lawyers on the panel, do you have a view as to what a cryptocurrency or a blockchain-based token is in law? Can you own it?
Would you like to
Okay,
start
for the
Lutz?
German market, it really depends on the perspective, because what I told you about BaFin, they say that Bitcoins or most digital currencies would be units of account and therefore financial instruments. But for example, if you ask the tax authorities, for example, what they say, they wouldn't say that it's financial instruments. Therefore, you wouldn't have to pay capital gains tax, for example, for gains with Bitcoins. So the authorities within one country, within one jurisdiction, do have a completely different view on it. So it's almost impossible to say Bitcoins are considered as something and then there's a stamp on it. It's really like you said before, you have to take a close look at all the facts of the case, not only for the regulation law, but for every perspective you take. And it's really difficult to say Bitcoins are a commodity or something else. It really depends on the perspective.
I think,
Adam from the UK?
Yeah, I mean, definition is key here. And, you know, if you look, say, what's happening in Holland at the moment, basically the community in Holland is split over a definition. You know, some say it's money or some say it's something else. The something else means it's unregulated. Money means it will be. Now, the whole community is divisive as a result, because you've got all of the exchanges that are, well, let's say, well capitalized, that wouldn't get a license and wouldn't be able to passport across the European Union, and so they're pushing for money. And you've got the libertarians, etc., on the other side that don't necessarily have a Bitcoin business or don't necessarily want to be regulated, pushing it for it to be something else. So it depends on what your intent is as to the definition that you want and the consequences of that definition. The question will be, define it as money in Holland, define it as a commodity in Finland, define it as a payment system, in another jurisdiction. What will the EU define it as? And that's really the crux of the matter for the European Union. We're kind of playing around with fragmentation at the moment and exploiting that to a certain degree, because you can locate your business in Luxembourg and passport across the whole of the European Union, where, you know, in other jurisdictions, they don't even have a position yet on Bitcoin. So there's fragmentation, but it's going to lead towards consolidation of the actual definition. Whether that's a good or a bad thing remains to be seen.
Brian, do you want to cover the US?
Yeah, I would just say that it depends on, it's not just what you say it is, it's what it actually does too. I mean, people call things lots of different names, coins, tokens, whatever, but it's the reality of how you're using it and what you're using it for. So in the US, you know, the regulatory authority that covers commodities has said, you know, Bitcoin per se we don't cover, but depends on how you use it, we may. The SEC has said, again, we don't view it as a security, but it may be depending on how you sell it, whether Bitcoin or another type of cryptocurrency. So it's a fact-intensive problem. It's something you have to look at and see not just what you say it is, but how it's actually being used at the end.
So there's a question for me, which is not just what it is, but how is it owned, or who owns it? So, you know, if you take a Bitcoin and you split it up into 3 pieces with 3 different entities or 3 different companies, that, you know, you put a requirement that at least 2 or 3 of those people need to combine in order to sign that asset away. Does anybody really even own that asset? You know, if they can't sign it on their own, they can't initiate a transfer on their own. Do they really have ownership or control over that asset? And how does the law affect those situations? I think that's actually something that's really unclear in the law at this point.
Well, it'd be a partnership.
All right.
I hate to cut you guys off. It's amazing. Great panel. So we're going to give you 2 hours next time. How's that? All right. Maybe
No one
2 and a
wants to hear
half.
from lawyers for 2
But you're going to be
hours.
here for lunch, right? You'll all be here for lunch?
we'll all be here. I mean, we're
So
here
you can't
for the
eat. You're going to have
duration.
to answer questions throughout the entire lunch period, right? No food. No food for the panelists. All right, let's give these guys a big round of applause. They were great. Thanks for coming all the way here from various locations. Okay.